It will be listed. Now, because there is no heavy board, we can
And
hear.
2015 matter, my lord. Hearing sign prayer. Yes, my lord. My lord.
But don't ask for adjournment once it is.
No,
Yes,
I
my
am not true.
Yes, ma'am. Obliged.
And Mr. Ragada will be, and Rahul will be.
It is a
overburdened for-
vigilance.
Vigilance
Vigilance
matter.
vigilance case also.
Obliged.
Yes.
Beg pardon, my lord. I am mentioning one matter, your lordship. Item number 15, my lord. I am on behalf of Mr. Rajesh Kumar Mahapatra.
Yes.
Mr. Mahapatra ko मांग और death is, my lord, for that reason. 2 weeks adjourned.
Pardon?
Item
2 weeks.
item 7, man. I pray next week any date.
You are seeking the matter which
No.
is not listed. You are seeking.
No, my lord, that
The matter which is
that-
listed. You are.
that matter, my lord, also
You have
say.
any problem? Then solve it. No.
Pardon to mention, Your Lordship, it's a
Seven.
criminal appeal of 2018 against the vigilance order, Your Lordship. It is, I am placing it for the consideration of the IA, Your Lordship, for the stay of
Court?
conviction. For the stay of conviction.
Appeal has already been admitted.
Yes, Your Lordship. It has been admitted and LCR was called for consideration of the interim,
Sentence?
2 years jail, Your Lordship.
Beg your pardon, Lordship. Item number 18, Lordship. On behalf of
Sorry,
Mr.
I'm so sorry.
Item number 18, Lordship. Praying for
18.
adjournment, Lordship. Deeply.
I may be pardoned to make a mention, Lordship, say fresh admission matter. I mentioned, Lordship, praying for tomorrow. And during trial, Lordship, this appellants, petitioner were on bail. And after the pronouncement of the impugned judgment, Lordship, they are on interim bail. The interim is going to expire on 20. So,
Sentence?
sentence 3 years, Lordship.
3 years.
My lord, item number 16, my lord. On my way to Miss Bharati Das, item number 16, not press.
1-6,
16, not press, my lord.
not press. 1-6, not press.
Revision tower.
Obliged.
Give the memo, please.
Hearing matter.
Item 6, your Lordship.
I think hearing matter.
1-6 now. He's not pressing.
Item 6, your Lordship. Permitted to interrupt.
Permitted to withdraw.
Item 6.
Yes.
Okay.
Any other mention?
Item 6.
Which mention? No.
Item 1.
Yes. What is this? Correction.
139 Act. Report of alert call for from the GMFs.
What is this? Allowed is not a- What is application is moved? Is there any letter from the judge? Target. How much time is needed?
No person. You Lordship. A prayer for the GMFs, you Lordship. Up to
How
Lordship.
much time I should give? 3 months. She had gone in a maternity leave. So 3 more months. 3 more months.
Nobody is appealing.
Nobody is appealing.
This was okay, Lordship.
Right. By the order dated 26/2/2024, this court has directed the trial court to conclude the trial as expeditiously. Conclude the trial within a period of 3 months. 3 months. Since the trial could not be concluded within the time stipulated by the court, the learned JMFC bracket LR and LTV Bhubaneswar, while the letter dated 27/5/2024 has sought further extension of time for concluding a trial for the reasons stated in the application. Taking into consideration the reasons stated in the application, the time for concluding the trial for the 3 months. 3 months. Yes.
My lord, after lengthy hearing, my lord, the matter has been disposed of.
May Lordship, I am for the filing the interim application on behalf of the OP number 2, Lordship.
Okay.
Lordship, kindly attention, Lordship. Page 25, annexure A10, Lordship.
25 of
I
application?
interim application, Lordship.
application is which application is it? 1492.
Yes, Lordship. Lordship, in this case, Lordship,
What are you seeking in this application?
seeking Lordship might give me directed to Lordship permission to OP number 2 to cross-examine the informant, because the informant exhibited some document in the court below, Lordship, and there is no given opportunity, by the court below to cross-examine the informant, the petitioner, Lordship, in court below.
Who are you? You are the informant.
No, I am the OP number 2. I am the accused in this case, Lordship.
What was the direction?
Director, Lordship.
My lord, kindly see the order page, order passed in the last occasion, my lord, which was disposed of para 3, my lord. My lord, that has been cleared, my lord. Para 3 of the order sheet, my lord.
Lordship, in this case, Lordship. In this case, Lordship.
Oh, the informant came and said that I don't want to press.
It's Lordship. Because Lordship, I am submitting some document in this case, Lordship. Lordship, kindly attention page 19 and 20. Number of cases are filed. The informant is filed.
Matter has already been settled.
Right, sir,
No, matter has not been
Correct.
because matter has not been settled against me, Lordship.
My lord,
Because no settled, Lordship.
other
In my against matter has not been
I
settled.
understand it. It is a fight between the two accused person, and one accused person is using the informant.
Like no, Lordship. Informant is a person litigant. I number of cases list cases of I submitted
My
the
lord,
page 19, 20, Lordship.
One person waited, but
My
his application, let us understand what
Page, Lordship, kindly attention page 19 and 20, Lordship.
20 of who? 20 of
Lordship. 1492.
149.
19 and 20,
Page
Lordship.
20.
Yes, Lordship.
Yes.
Number of cases he has filed, and because I am a poor person, I am a auto driver, Lordship. I have lost everything, Lordship. I have lost because I am
What was the office?
because I am the OP number 2 is a auto driver, Lordship,
But
and
you are an accused in a case.
accused in
The
this case.
complainant doesn't want to prosecute you.
Yes,
Still
Lordship.
you want that.
Because Lordship, can I attention page 25? What am I saying,
You
Lordship?
may have some other grievance, but not in this proceeding.
No, Lordship. In that, who is that, Lordship? The informant is appeared in the court.
Where are you reading, sir? Yes.
Page 25, Lordship. Kindly attention.
25.
Yes, Lordship.
Please read it.
Accused person are absent, but allow representation under section 370 CIPC for today.
Proceeding dated?
8/11/2023, Lordship.
Huh?
Lordship, I am reading the order sheet, Lordship.
Which date? Order.
Order 8/11/2023, Lordship.
Pages are wrong.
Page 25.
Not 25, sir.
Annexure 810, Lordship.
Yes, that is page
20.
20. Yes. Accused persons are absent.
But allowed be repainted under section 317 CRBG
Okay.
for today only. Mohan Bhair is present, open number 2. And a file Hajira, no PW today, issue summon to the rest of CS witnesses pitching on 30 Sega 2023. So also my knowledge is that that was pitching on 30 Sega 2023 on advance in 17 2023 after last order. Those case record is put up today being advanced by learned APP files Hajira of one witness is examined and cross-examined and discharged as PW2 informant, Lordship. Exhibit are marked and exhibit P1 and P1 by 1. No other PW today put up on date fixed for trial. So, Lordship, in this Lordship, because my step is not there in record, because I am not appear, I have no.
Then you are agreed by that order. You should have challenged that order. You have not challenged.
Because I filed a recall petition before the court below.
Where is, have you challenged that order?
Yes, Lordship.
Where is that?
Because recall and the Lordship page 60.
Sorry, one minute.
Not that item one, our name is.
Your
I don't
name,
know whether extension of my lordship allowed this.
I have extended 3 months. Because the lady judge was on maternity leave. I have extended.
Yes.
I record the
Presence of.
Lordship page 15, Lordship. That I in page 15, Lordship. I filed a recall petition
before the
before the court below.
Okay.
And recall petition is allowed.
Yes.
And that order of challenge before the Lordship, before,
He challenged.
yes, Lordship, informal challenge, these orders. And that is not allowed, Lordship.
No, he has stated that he does not wants to proceed the case. For that is the lordship dispose the case. Now he is coming here, my lord, filing a petition.
What is the
To
offense?
cross-examine.
What is
Why
the-
he did not agree to proceed with the case, my lord? How can he cross-examine? Their prayer, my lord, the IA.
What is the offense?
So, Lordship, that is
What is the offense
offense, Lordship,
against you?
against Lordship. That is the offense is the. Offense is 341, 320, 295, 536, 37 and 35, I guess.
You should be happy he is withdrawing it.
No, Lordship, because, no, because Lordship, I want to cross-examine, because cross-examination is required in this case, Lordship. The person has filed 27 other cases against me. And the number of CRMP case filed against me.
You have a.
So because
you have a remedy.
Lord- Lordship-
Malicious prosecution.
Lordship, for the sake of argument, I will act, because they have admitted cross-examination, because matter is settled and that I will acquit it. So, Lordship, that is no benefit, Lordship, because I will not file a defamation case against this person,
You want
Lordship.
to cross-examine him to get the defense in other cases.
No, Lordship.
That's your idea.
Because,
Lord, there
because 4 number of cases, 2 cases already been that order passed, Lordship. So because that no give you opportunity to cross-examine, because of.
And you are sure that in this case you will be acquitted.
Yes, Lordship.
Now also you are acquitted. Gyan Singh says that don't burden the court. If you know that it will be ended up in acquittal and
No,
close
no,
it.
but
And the complainant says that I don't want to proceed against you.
because
Can you force the complainant? No, you have to proceed against me.
because Lordship in this case, because in particular this person, Lordship, the file of number cases, the
I
put behind the
understand it.
behind the bar, where the cross-examination is
It is only
coming.
question whether police examine you or not. That is the matter.
No.
Taking that consideration, your lordship.
No, I am not examining, Lordship.
My lord,
Therefore, defense
there
lawyer
is a author
cross-examination
co-accused, my lord.
putting a single question.
My senior is appearing for the other co-accused persons.
My in Lordship in 17, 17, Lordship, order is passed, Lordship. Because that advance is.
Order dated 21st 5/2024, your lordship passed the order. That is my lord, correct order, my lord. See, the Bidul 2 doesn't want to proceed this case, my lord. But that is
That's the whole difficulty.
and he come forward now
Even-
and says
even-
that I will question.
Even if you will put them to trial, it will end up in the acquittal because he is not supporting the prosecution. That's the idea of dropping it.
No,
I think you have other remedy.
no, Lordship, because FIR was already been executed. Because they have not put the cross-examination, because they have admitted in FIR.
You are having other remedies and I don't think.
But his prayer, my lord. I am read out his prayer, my lord. In view of the aforesaid facts, only it is respected prayer that is honorable to my gracious will be pleased to admit this written application. Further modify the improved order in CRM such and such passed by this only on 21st 5/2024 by giving due opportunity to the opposite partner to cross-examine in the petitioner.
When will you cross-examine? When he says something against you, he
Question
says
of
that I don't want to proceed against you.
what is the
Lordship, I am ready because I want to be.
You may be ready, but law to do experiment.
No, because the opinion number 2 is ready because he wants to be
Sir,
conviction
Sir,
and go to
better
bed.
better you withdraw this application with what kind of liberty you want, you tell me and record. Otherwise, better you do. Because you can't cross-examine. He doesn't say anything against you. Rather, he says that I don't want to proceed.
proceed with this case.
You are accused. Can you force a complainant? No, you must proceed against me
No,
because you are proceeding against me in other
No, Lordship, because my rights has already been cut on,
My
Lordship.
lord, there is 3 accused person, my lord.
Because
The other 2 accused
other
person.
two accused person.
My-
other,
Lord
I
Singh
am
is
not,
appearing,
Lordship,
my-
I am not bothered other accused person.
Withdraw this IA with a liberty to What do you want? What kind of plea do you want?
We have to file the application before the court below for consumption to the.
To avail all the remedy under law. All the remedies.
My lord, miscase,
Whatever.
petitioner in miscase, my lord.
Main petition has already been disposed. This is an IA.
Pardon, my lord. Item not 20, my lord. 2 weeks after. 2 weeks after, it's
So you were 2 weeks after. Yes. Yes.
May I please, my lord. I for modification, my lord.
Yes.
Your lordship's directed to please to quash the individual, my lord. For the law and trial court, going to quash the individual, but not inclined to release the petitioner on bail, my lord.
What can I do?
Well, case of the 1999, the original record not found.
Offense, what is the offense?
307 and others, and omnibus allegation, numbers of people.
That's right, but I can't grant bail. No? Where is that rejection order? You challenge that order. Where is that? Has he rejected?
No, not rejected, but
You ask the judge.
yes, my lord,
You ask the judge, what are you going to do?
after going through the order, your lordship's order, no, I will not release bail order is not there.
I can't, sir. I can't grant you bail. Because you ask for a cancellation of BPW, I cancel it.
Problem is,
Don't appear that.
problem is that 99 record, man. After super cyclone.
More of a reason that you will be enlarged and bail. If it doesn't happen, then come.
Petitioner released on
But
bail.
let us do one thing. I'll keep it pending and go. If it doesn't happen, then tell me. I'll allow. Okay. That's a better idea. Let it be there. Go and surrender. If it doesn't happen, then you tell me so that we can find out something. Okay. Let it be pending.
Obliged, man.
Your apprehension is taken care of now.
Yes, madam.
Simply keep it pending and give a date so that
Next week.
1 week after 1 week after.
Yes, ma'am.
Meanwhile, you do it.
Yes, ma'am.
If it doesn't allow, then I
Yes.
will
Yes,
see
ma'am.
that you are out. Okay. 1 week, exact 1 week, sir. And go and do it within 1 week, whatever.
Yes, ma'am.
Item 4.
Item 4, file IA for modification of order.
Yes.
Correct the 1CC case number 126 of 2020.
14.5. 14.5.
14 order. Yes, madam.
1CC case number?
126 of 2023 है ये लिखा है 2003.
क्या करते हैं? Oh, in the prayer you have written, just see the main.
Yes. I have wrongly
You have
written.
mistake.
Yes, yes. Yes.
Right up. Then comes for the petitioner, submit that instead of the ICC case number 126 of 2022, emergency in the petition. We had written the ICC case number 126 of 2020. Therefore, the error has occurred in the order dated 14/5/2022. Therefore, only this is modification. Modification is allowed. One case 126 of 2023 occurring in order dated 14/5/2024 shall be read as 1CC case number 126 of 2020.
160 2003.
2003.
Three.
So, correct.
Then 3.
2003. You have written that what that's all.
23 बदला 2003.
Item 5. And the petitioner is also allowed to correct the petition.
Yes.
Today. Counter. You correct it and.
Yes.
Yeah.
May I please, Lord?
Yes.
Modification of order dated 15/5/2024 mention date टा भूल होची 23/4/24 होची 5/3/24 NBW issued 5/3/24
5/3/24 23/4/24 तो लिखा है इसमें
23/4/24 टा 5/3/24
प्रेयर तो लिखी जो तमे देखो ना प्रेयर देखो
आ प्रेयर टा थिला सेटा
ताको देखि तो करा कोन करियो आप
नहीं सर्टिफिकेट कॉपी टा जो आसला
Correct and
you change the
correct कर दो.
correct and कर दो NBW dated 23/4/2024 and तापर इतो
नहीं ता पूर्वटा हिच
5/3/2024
5/3/2024 मार्च 5 रे फर्स्ट
मैंने कौन सा पढ़ देखी मुड़ी submits that inadvertently in the petition, he had mentioned that the NBW was issued on 23/4/2024, whereas after seeing certified copies, certified copy found that indeed NBW was issued against the petitioner on 5/3/2024. Currently, he seeks modification of the order dated 15/5/2024. The application is allowed, petition is directed to petitioner is granted the permission to correct the dates in the petition. And accordingly, the order dated 15/5/2024 is also modified, modified to the extent that the LBW is issued on 5/3/2024 is verified.
To which time to surrender?
Will be of the aforementioned confusion. Petitioner could not appear in public court. 30th June is there. 30th June. But item 8.
Item 6.
6 subject.
Withdraw.
Withdraw. You are saved. Yes. Item 8. 8. Modification. What is it?
307 arrived for 5 years.
Press matter.
Yeah. Item number 8, my lord.
No, this is press 1 or whole one?
Admit it.
What's the counsel?
Bhavani
One
Sankar
is
Das.
Here, Krishna, the matter is coming for final disposal. In the interest of justice, urgently, next week. Otherwise, you will have funds immediately. Okay? Next. Item 9. Same order. Please sit down.
Same order.
10. Item 10. No further implementation. On 9/4/2024, the matter was rejected and the clear-free ceremony of your part. When the matter is called up today, nobody appeared. Finally, to argue the matter, these two matters. Item 11. If nobody appears for this research, the matter will be taken up for hearing by appointing the question. Item 11. That was reached on 11/10/2023. The council for the petitioner had submitted that we had no up-to-date instruction regarding the up-to-date instruction in the matter. Accordingly, the matter was adjourned. When the matter is called up today, none appears in the interest of this case, and as a final opportunity to do the matter. Item 12.
Same order.
No, last time none appeared.
No.
These are revisions, na?
Legality Council.
The matter was registered on 22/4/2024. None appeared on that day. In the interest of justice, the matter was listed, directed to be listed on 30th April 2024. Next one.
Madam. Item number 11, madam. 11. This is telegram.
This was heard by your lordship on earlier
But last
occasion before
occasion,
vacation.
none appear for the petitioner.
No, madam.
No.
11.
Last-
Previous matter, madam. 11.
This is 12.
12. Lordship holding 12. madam.
Well, let me complete. Eleven, huh? Yes. Yes.
This was heard by your lordship on earlier occasion, my lord. Lord, the petitioner has been convicted.
I have not heard.
Your lordship has heard.
But there is no proceeding.
No, it was before vacation. It was on
No.
25/4/2024.
Where is the proceeding? Here.
25/4/2024, your lordship had heard this matter earlier.
There is no proceeding.
It's on the.
The last proceeding appears to be on 11/10/2020.
No, thereafter, the 25/4/2024, it was listed.
They
And
are paid for that.
354, your lordship must be remembering, 354, your lordship said that it cannot be, my lord, converted to imposing fine, my lord.
Yes. What
That
is it?
that is that case, my lord. My lord, the petitioner has been convicted here under section 354 IPC and
Three-
sentenced 354 IPC. Although prosecution was initiated under section 376, 511 earlier, my lord. But ultimately, the trial culminated by convicting the petitioner under section 354 IPC and
By the trial court.
by the trial court, my lord, sentencing the petitioner to undergo RI for 1 year.
Right.
My lord, now, my
What
lord,
happened in the appeal?
my lord, in the appeal, it was confirmed.
Confirmed.
Thereafter, I am before your lordship in revision application, my lord. My lord, here, your lordship, my lord, the petitioner's incarceration in jail custody during my lord trial period, it was from 10/5/2011. I'm sorry, my lord, sorry. The petitioner was in custody since 24/2000
24,
2002.
24,
24/10/2002.
10/2020.
24/10/2002.
Okay. Next.
And he was bailed out on 21/2/2003.
22
2003. Near around 4 months, he is already in custody. And thereafter, during appeal period, my lord, after appeal, my lord, he was arrested and was released on bail. Of course, my lord, when he was arrested, that is not there on record, my lord. I was verifying the LCR. It is not available there, my lord. But the appeal was disposed of, my lord, on appeal order is
What is the minimum sentence? 354.
the minimum sentence, my lord, prescribed is
Only 354, no?
yes, 354, only 354.
Not be less than 1 year.
Not be less than 1 year. But I have got one decision, my lord, following the decision of the Honorable Apex Court, my lord,
Forget about
the
decision.
court,
What we will do is probation.
no, provision, but provision section 4 of PO Act is also there, my lord.
That's what I'm
That can be applied,
I'm allowed.
yes, yes, applying the provision of
Allowed. Section
4 of PO Act.
4 of PO. ठीक है? Judgment is your. Sorry about that. You want? Section 4 of.
You have to, let me.
Yes. Item 30.
Made with lordships.
You can pronounce it day after tomorrow. Huh? This will be all judgment one. Yes, this is 13.
13 lordships. Your lordships, petition is convicted on section 279 of IPC, and he is sentenced to undergo imprisonment for 2 months and pay fine 250 and default to undergo imprisonment for 15 days. And for
279,
the,
sir.
and
279.
279, 37 of IPC, the convict is sentenced to undergo imprisonment for 6 months, pay fine 500 and default to undergo imprisonment for a month of for the offense 38 of the IPC. And for the offense 304A, the convict is sentenced to undergo imprisonment for a period of 1 year.
304A was
For a period of 1 year and pay fine 1,000. So higher punishment is 1 year, your lordships.
Okay.
And 1,000 is of fine, your lordships. Your lordships, fact of the case, your lordships.
Now, what happened in the appeal?
Appeal has been confirmed. your lordships. Confirmed. Your lordships, based upon the PW7, he is the alleged to be the eyewitness of the occurrence, your lordships. Your lordships, as per the affair,
You show me relevant paragraph of.
yes, lordship. I am showing you, lordship. Page 9 of the affair, lordship, kindly see.
9.
Page 9 of the affair. Page 9, rolling page 9.
Come to the trial court judgment.
Yes, lordship, sir. And before that, lordship, I am coming, lordship. One vehicle is involved, OR 068792.
That's the affair story.
Affair is, that vehicle is involved, lordship. But police has seized another vehicle. I am coming to that page, lordships. That is page 18 of the judgment, trial court judgment. Para 8 internal page 18.
Page 18, yes.
Para 8, second paragraph, lordships.
Subpara.
Subpara, lordships. The question remains whether the present accused has accused in the accident as a result of.
1 minute, sir.
Yes.
Okay, please. 1 minute. Yes. The question remains.
The question remains whether the present accused has caused the accident as a result of deceased sustained injuries and ultimately died. In the affair, the registration number of the offending scooter has been mentioned in OR 068792. But in this case, IO has seized one scooter bearing registration number OR 069418, registered in the name of Dilip Kumar Sahu. He has also seized the driving license of the present accused under seizure list, that is your lordships. Apart from that, your lordships, occurrence took place on your lordships as per the affair on 16/8/98. 16/8/98, your lordships.
16/8/98.
98.
Yes.
And your lordships, offending vehicle is another lordship. Seized another
That's
vehicle, offending vehicle is another lordships. As for the affair. And your lordships, see the PW7 evidence, your lordships. PW7, he is the eyewitness, lordships, occurrence. No other eyewitness is there. He was coming with the, it is alleged that as per the
trial court deals with PW7.
PW7, lordships.
Come to 15, page 15, para 6.
Your lordships, may I peruse, your lordships? I know the informant, I know the accused. This is in this case.
You are reading the evidence.
Paragraph 6.
Paragraph
Page
6 up
15.
to the page 15, paragraph 6.
Schedule 7. Start from Schedule 7 is Akulo Naik. Page 15, paragraph 6. Page 15.
Yes, your lordships. Akula Naik and her, as per the FAR story, he has committed with the deceased, coming with the deceased in the bicycle when the accident took place, according to him, 17/8/98 at about 7:30 p.m. while they were coming.
FIR says
16, Your Lordships. Your Lordships, see the FIR, Lordships. 16/8.
8.
16/8, 19, Lordships. Lordships, could find, Your Lordships, page 7 of the FIR, Lordships. Date of occurrence, Sunday, that is 16/8/98 at about 7:30 p.m. It is very doubtful, Lordships, whether accident took place on that day or not.
That you get it para page 12.
Page 12.
Page 12. First.
Yes, Lordships.
On it evening. Yes.
The case of the prosecution as per the FIR, Lordships, 16/8/98.
Yes, Mr. Raghuda. These are 2 points enough.
That is, my lord, evening, that is true, my lord, but in fact, my lord, what happened?
Vehicle is something else.
My lord. No, vehicle, my lord, that has been clarified by the trial court and also the IO, my lord.
And
I'm ready out, my lord.
Yes. What about the timing?
My lord, timing is same, my lord, but the date, my lord, here, my lord, evidence of according, my lord, date, my lord, he has stated that on 17, my lord, but in fact, the FIR is 16, my lord, 16/8, my lord.
But how will you have you cross-examine him?
My lord,
Cross-examine him and create a doubt.
but they have not created.
Declare him as a hostile.
They have not, my lord, the cross-examine on that point, my lord. The date of occurrence not.
Why should it goes in their benefit?
They have not, my lord, even when they have not put that question, my lord. They are disputing the date of occurrence, my lord.
But you should have declared him hostile. You didn't do that.
That is not there, my lord. But in fact, my lord, I am read out, my lord.
Show me the
my lord,
vehicle.
My lord, substandard, my lord, read out to paragraph 6.
6. Okay.
6, my lord.
Yes.
Accordingly to him, 1998, at about 7:30 p.m., while they were coming, the accused came in a scooter from the Nagena in a rash and negligent manner and hit the deceased. As a result, fell down from the cycle and sustained severe injury on his person. After an accident, the accused went away, leaving the scooter on the accident spot. He went to the house of the deceased and intimated about the same to his family members. During cross-examination, he could not say the registration number of the scooter as he was illiterate. Besides that, accused another person was also coming in the said scooter as a pillion rider. P.W. 8, my lord, the informant, my lord, son of the deceased. P.W. 8 is the informant. He has deposed that due to rash and negligent driving of the scooter, the accused had caused the accident. Hearing about the accident, he went to the spot and found his father lying on the ground with a bleeding injury on his person. The scooter was also lying on the spot. He ascertained from the person present on the spot that the accused was driving the scooter and after causing the accident went away. He shifted his father to Dhenkanal for treatment, and as his condition was serious, he took him to Cuttack. On 23rd/8/2098, while his father was undergoing treatment, died in SC Medical College Hospital, Cuttack. On 17/8/98 morning at about 8 a.m., after returning from SCB Medical College Hospital, he lodged the FIR. FIR on the next day, my lord, 17, my lord.
And he is not an eyewitness.
Marked as Exhibit 3. During cross-examination, he admitted that he is not an eyewitness to the incident. By the time of his arrival on the spot, accused had already left this place. During cross-examination, he stated that one of his friends had scribed the FIR as per the instruction, and his mind was upset. That is very, very important, man. His mind was upset. At that time, he could not go through the FIR. He had disclosed the registration number of the scooter involved in the accident as OR G9418. Correct scooter number, my lord. He has mentioned, my lord. Then, my lord, P.W. 9, the IO of this case, has during his investigation, he visited the spot, which is a public road in the between village Zili and Nagena. He sees the accident scooter and the document from the accused, my lord. Very important. Accused Tapan Kumar Sahu on his production in the presence of a witness under a seizure list marked as Exhibit 1/2. On 17/8/2098, he arrested the accused accused and the voice of the Gondia PS released him on bail. He left the scooter and its document in the Jima of Dilip Kumar Sahu, my lord. Then the owner of the under Jimanama marked as Exhibit 2 on 27/8/98, he received a message over VHF from the IIC of the Mangalava PS Kotak that the injured expired on 23/8/98 at SC Medical College Hospital while undergoing treatment for the injuries. A case was registered in the said PS as UD case number such and such. The police of Mangala PS made inquest over the dead body of Darlam Naik and sent for postmortem examination. The inquest report has been marked as Exhibit 5 and postmortem examination report as Exhibit 6. During his investigation, he also sent the letter to the RTO Dhekanal to ascertain the ownership of the accident scooter bearing number FR mention OR 06 8792. And he was intimated.
The scooter which was recorded from the spot is the right scooter where the number is there. But the FIR some other number was written.
FIR, my lord. The scooter was seized from the spot. The right scooter that is belongs to the petitioner, my lord. But in fact, in the FIR, my lord,
some other number is written.
The informant stated that he has given the correct number, but the scribe in the another person scribe the FIR, my lord. He has not written the correct number. That is the my lord, the clarified, that has been clarified by the 3 scooter number. And the accused, my lord, voluntarily, my lord, see, given the documents also, they are arrested. He has not raised any question that
he is not the owner.
But that is not their pre.
Number is very key. The number is original number is 9418.
My lord.
But it is 8792.
But that has been clarified by the informant, my lord. His deposition that he has given the correct number, but the scribe of the FIR not put the.
And this number is in the name of Khogeshwar Naik.
My lord, that is one of the which number has given by the scribe in the FIR.
And your lordships,
that is another person, Khogeshwar Naik, Amba Bahali, who was the SDO elected Talchar. On being contacted the accused, his father disclosed that they had no relationship with.
Sufficiently clarified.
My lord, that has been clarified, my lord. Another thing, my lord, he is saying that my lord, scooter not there. And date also, my lord, that has been clarified by the informant. Since he is upset on that day, he has taken to his father to the Deccan hospital. Then after returning from there, they had lost the information, my lord. And the scribe is another person, my lord. He has put the wrong date and the and PDO 7 eyewitness.
He has been examined, scribe.
My lord, PDO 7. My lord.
Who is this scribe? Has he been examined?
No, my lord. Scribe express.
FIR is lordship written by the informant.
The scribe was examined or not? No.
No, se kono scribe call anyway. Borono Naik.
Borono Naik is the scribe. PW8. Borono Naik said that Borono Naik is the brother, the son of the
informant.
I have told to some scribe the FIR.
Who is the scribe?
That has not been mentioned, lords.
That has not been mentioned, my lord.
And whether he was cited as a charge-sheeted witness?
No,
LCR not with me,
no,
my lord. LCR will not be available there, my lord. And that about my lord with regards to the date, my lord, that has been clarified.
Then unless you examine the scribe, unless you examine the scribe.
But the eyewitness there, my lord. My lord, the eyewitness PDO 7, my lord, who has accompanied with disease, my lord.
He says that accident has taken place in 17.
No.
16 years old. He has taken place.
That's the problem.
17 years old.
Then all, but he has stated in the evidence 17, my lord. But in fact, he know the accused, my lord, prior to the incident and also after the incident.
The scribe, the PW7. Does he say about the car number, vehicle number?
No, he has not stated, my lord, about the vehicle number.
How will you believe him?
But he stated that he known to the accused prior to the incident and also after the in the dock, my lord, he identified this man is driving the vehicle and caused the accident, my lord. That is there, my lord, evidence, my lord. PW 7, my lord.
What is the maximum sentence?
Your lordships, another point in lordships. I am saying why this petition, PW 7 should not be the eyewitness lordships. I am showing you lordships. FIR story was lordships. He was coming with the deceased lordships. PW 7. Lordship, kindly see the informant's witness evidence, lordships.
PW8.
PW8 Lordship. I am the informant. I know the accused. The deceased is my father. My father died due to scooter accident took place on PWD road in between Jilli Nagina near about 16/8/1998 and about 7:30 p.m. While my father was returning from Jilli to our village, one Tapan Saw of the village, he was driving the alleged accident scooter. The registration number of the said scooter was 9418 something, Your Lordship. Nowhere he has stated that that person PW7 was coming with his father.
No, he has this categorically stated.
PW7
as per the PW7.
PW8
PW7 specifically stated that I had accompanied with the deceased and when the accident took place, my lord. The accused himself and came in with his scooter and made the accident, my lord. But the trial court as well as the appellate court, my lord. My lord, they have not disputed the evidence of PW7, my lord. Who is the eyewitness to occurrence, my lord? He known to the, my lord, the accused, my lord. While they were coming, the accused came in a scooter. My lord, PW7 evidence, my lord. While they were coming, the accused came in a scooter from Nagana in a rash and negligent manner and hit the deceased as a rider fell down from the cycle and sustained severe injury on his person. After the incident, the accused went away, leaving the scooter on the accident spot. He went to the house of the deceased and intimated about the same to his family members. During cross-examination, he could not say the registration number of the scooter. He has, since as he was illiterate, beside the accused, another person who was also coming, besides the accused, another person was coming in the said scooter as a pillion rider. What's evidence? He known the accused.
His evidence should be corroborated by the any witness lordships. That has not been.
Is not an eyewitness to the occurrence.
He says that I have not eyewitness. Eyewitness is only 7. 7. The testimony of 7 is doubtful because he says something. He says that it has happened on 17, whereas the FIR says 16. To that extent, it is doubtful. In so far as the vehicle is concerned, a wrong vehicle number was given. PW8 says that I told the right vehicle number, but the scribe has written wrong one. But the scribe you have not examined.
And your lordships, in the FIR itself, he has not stated that it has been scribed by someone else and I am signing it. That has not been mentioned in that FIR, lordships.
Show me the FIR.
Your lordship says.
Give me.
I am perusing the FIR, lordship.
Give me that FIR. Give me that. How much you have undergone?
The FIR itself shows that the signature of the PW8, my lord. The handwriting of PW8, my lord, the signature
that is,
and the must have been scribe another person, but the PW8 sign only sign, my lord.
Sign, the handwriting is also
different, my lord. Differ, my lord. Varun Naik has sign in the below, my lord.
Just see the handwriting. Varun Naik.
My lord.
The signature.
Varun Naik only.
Same your lordship.
Varun Naik, handwriting different.
This scribe is again scribe lekha hua katha. It should be written in the FIR, lordship. It has been scribed by. Written by then.
So the signature Varun Naik is signature differ करते. मतलब first line, my lord. निवेदन अपेक्षा कि मु वरुण नायक. But the first line, my lord.
Then he
and in the my lord, last, my lord, the आपण विश्वस्त वरुण नायक differs, my lord, the signature, my lord. For that, he stated that the FIR sky by some other person, my lord. I mean, not there, my lord.
Vague argument, lord. It is very
no. That is, my lord. It is not valid, my lord. The signature, my lord, of the the signature of the informant, my lord, and also the name of the informant is mentioned in the first, my lord, the FIR, my lord. That has not been valid, my lord.
Generally,
in the naked eye, my lord.
Generally, in the FIR story, lordship,
if his signature, he has written. Just Varun Naik signature, just the
my
handwriting also.
Twice Varun Naik, but in the top Varun Naik mentioned, my lord, the first line, my lord, and in the last, my lord, Varun Naik. But that is, my lord, does not tally, my lord. I think my lord, told the expert of the expert.
Very big story.
True grounds here also.
And in
Last induction is the mission.
and in the informant, he has not stated that in the evidence that PW7 was with his father.
No, no, but P.W. 7 said that he
Well-
informed the family members, my lord. Went to the house of decision and informed, my lord. That is the evidence P.W. 7.
The third page 11 signature English he is writing Varun Naik. Just see Varun Naik.
That is in English also.
Hmm? So I think
Though the P.W. 8 not
Everything is doubtful, lordships.
just see the handwriting here, Vishwanath Das and SI police so and so and Varun Naik. Handwritings are same. The IO himself is trying to perform.
IO investigation out a vehicle का पूरे चला गया. It is only more, I think your lordships जो for compensation lordships that vehicle has been put.
You tell me whether he got the compensation or not.
That instruction I have not, lordships.
Please get it. At least you should get the compensation.
Definitely he has been getting get lordship because this affair.
You ask your client, I am reserving the judgment. You are entitled for acquittal, but at least see that he should get this.
That evidence, how could I collect your lordship?
Not I am. Ask your client.
Client.
MSCT case ହେଇଥିଲେ notice
MSCT
ହେଇଯିବ।
ହେଇଥିଲେ କିଛି ପଇସା ମିଳିଥିଲେ
Notice ଯାଇଥିବ।
somebody's father has died.
What the accused has committed?
That's right. That I will understand it. Just show it to Mr. Raghunath. Just see.
किसी नहीं
Just see. Back side of Varun Naik, he will just sign it.
Everything has been manipulated.
Not manipulated. So casually they do it.
Right.
That's the problem. It's
Yes,
not intentionally not manipulated.
हाँ, सेटा बस
Sign करो कहाँ किया क्यों लिख दियो. It is casually done.
casual done.
But somebody's liberty is at stake. Somebody's this thing is at stake. Somebody's father died.
Yes,
These
sir.
people don't bother.
And the MBA has not been examined in this case. Accident has not been proved, lordships. It is a fit case where it is this petition should be acquitted, lordship.
Yes,
sir.
That is your lifeline. Don't take it. But still, I think you should get some information regarding this. Ask your client, not that you can't. You must be knowing because he might have been examined also in the MHT case. Just get it. The
I will
first
check.
point is date of FIR, date of FIR in date of
In fact, lordships, I have written a letter on 6/11/2022 to this client of lordships. He did not turn up the lordships. Too late. Nothing.
There are 2 points, huh? Basically two.
No, your lordships, I am coming, your lordship. First point is date of affair.
Date of
Date
affair
of
and vehicle.
accident. Date of accident, your lordships. Date of accident is the first
Right,
point.
right.
Second is
Vehicle.
vehicle, your lordships.
Third,
Third point, your lordships, PW evidence should not be treated as eyewitness, your lordships, as because PW8, the informant, he has not stated in this evidence that his father was, this PW7 was with his father.
presence of, third point, presence of.
Yes, lordships. That is very vital, lordships. The PW7 evidence has not been corroborated by any of the witness, lordships. It is, it's.
Seven citizen, he went to the house of DC and informed the
Yes,
matter.
that is.
But getting from.
Yes, lords, I will take chances.
Yes.
I will also prepare written note of argument.
Yeah.
I will, if your lordships permit me, I will submit a written note of
That's
argument.
very good.
Yes, lordships. Order reachable, lordships.
Item 14.
Yes, madam.
Yes. The petitioner was convicted.
Ready?
Yes. Fine. I'll try up to my level best. The petitioner was convicted 2 years and fine of 1,000 for the offense 452 IPC and 7 years with 5,000 fine in default of 6 months for offense under C76. And out of 7 years, he had already imprisoned 3 years and 8 months. He was in custody 3 years, 8 months, 10 days.
3 years,
8 months, 10 days.
already undergone.
3 years, no, out of 7 years, 7 years. 7 years for 376 IPC. 7 years. He was convicted for 2 years for 452 and 7 years for 376. Out of that, he has undergone 3 years, 8 months. During appeal, this Honorable Court has granted him bail.
3 years, 8 months.
8
Can
months.
you give date of?
Yes.
Give me.
Yes.
Custody taken into custodian. Trial court time.
At 23 March 2006.
23/3/2006. Okay.
Yes.
Yes.
Released on bail 18/10/2009. But he was
10/2009.
18/10/2009. This Honorable Court disposed of the bail petition, but he was released on next month. He was released on 5/11/2009. 11/2009. In the month of October, this Honorable Court disposed of the bail and
376.
next one. Yes.
376.
Yes, 376. Only here in this case, my lord, medical examination was held the next day. Doctor opined that there was not recent, there is not, the bodily injury found in the body of, no bodily injury found on the body of the victim. The victim has changed her its also. 1 minute.
No, it's
Yes.
376 or
Other offenses are there.
no,
452 and 376.
No, 376
7 years.
ABC anything that's all? No, only 376.
376.
376.
But 376 minimum sentence is 10 years.
Only 7 years.
Imprisonment of which either disposition for a term which shall not be less than 10 years. By the extent of- by the-
Not less than 7 years or may extend to my lord, 10 years or life. That is my lord.
Yes.
Very good.
Not less than 7 years, but extend to 10 years or life.
No, it shall not be less than 10 years.
But that is the
Amended.
new act.
Amended.
Old act, my lord, may said not less than 7 years, may extend 10 years or life, my lord. That is that. For that is my lord, 7 years, my lord.
So I was
Maximum.
thinking of undergone, but that will not.
That will.
That will not. Yes, what are the evidence?
Yes. No eyewitness is there. Only
376, where we.
yes. Only testimony of the victim. There was no corroboration. No corroboration.
Only prosecutory statement.
Yes.
And any corroboration, anything of.
Yes. No properly corroboration is there. There was a previous enmity of their civil suit is pending. That thing was not considered by both the court. Civil suit was pending. Affair was lost after 1 day. And fact of the case is that
You structure your argument one after another.
yes.
Take out a point and develop that.
Yes. Fact of the case is that there I want may I permitted to read the order of trial court, page number 25.
25.
The prosecution case in brief is that on 22/3/2006, about noon time, the victim was taking rest on the court. At that time, her nephew Surendra Kabata and niece Sasmita Kabata were inside the house. The outside door was closed. At that time, accused Sushil Barik entered into the house and asked the victim who administered poison in his tank. On that day, someone has administered poison in his tank.
Poison in the tank.
ता पोखरी रे विष पके दिले किए सबु माछ मरि गला से लोन करिकी करथिला से ताको पचरिया को गला. At that time, accused Sushil Barik entered into the house and asked the victim who administered poison in his tank. When the victim replied that how could she say, then the accused gave her two kicks. Two kicks below. One hearing had considered the accused when he protected the accused, asked him to leave the house. Then the accused asked the nephew and niece to go out from the house. The accused bolted door from inside and threw the victim on the cot and tore her sari blouse and committed rape on her by force.
My lord,
Offense.
offense, my lord, under section 47A of the Bihar and Odisha.
2CC case.
2CC case, my lord.
47A of Bihar.
Yes, sir.
Who is the lawyer not appearing? Bhavani Shankar Mishra. You are appearing?
No.
Just a minute. And you take assistance from Mr. Raghunath.
Yes.
And he will help you.
There are decisions are there.
He will help you, huh?
Yes, I have taken also two decisions. There are when civil litigation.
He is not your opponent. He is senior. He can assist you.
I know him. He is very liberal to all.
Not a matter of liberal. He is assisting the court.
Yes.
Correct.
Assisting.
He is not opposing.
Not opposing.
Prosecutors are not there to oppose. Prosecutors are there to only assist the court. If there is a case in your favor, he will definitely say that
Yes, I know.
So he will give you the judgment also.
Yes.
Our favor, many judgments are there.
You take the judgment,
Right,
cite it, you get an acquittal.
Yes.
Yes.
Agro once by 6 Jari, these are sold.
Non appear करके out लगा दी थी date के.
Yes.
तो कोई भी
Out.
Non appear on behalf of the petitioner because last it was listed on 15/5/2015.
Yes, my lord.
Thereafter it was not listed.
How did
Non
it?
appear for the petitioner. In the interest of justice, again, one is correct. Non appear case will be खत्म. Yes. Item 19.
19, my lord, they were studying, my lord.
Pray for
After all, they praying for Arjun.
Arjun.
Accordingly, and count for the petitioner. And adjournment is short, and then 20.
Okay, adjourn. Completed.
Let us see, we can finish up couple of revisions. You prepare and come. If small matters are there, we will finish. Yes, madam.
Item 15, Your Lordship. On behalf of Mr. Rajesh Kumar Mahapatra, mother expatriation. End of next month.
Yes, yes, yes. 2 weeks adjournment was.
Yes, sir. Obliged.
Thank you very much.
Online